We have Chris Markey, State Representative Chris Markey, joining us at this particular time. He is also an attorney. I've seen him on the defense side of the block, but he's also been on the prosecution side of the street, and he has been in front of Judge Moniz before. It's still morning, so good morning to you. How are you?
Good morning. How are you?
I'm fine, State Rep. Did you watch, like most of us, what the judge said today?
Yes, I did.
And your thought?
He's clearly thoughtful and deliberative, which is one thing that we always want from the criminal justice system. The other thing is he clearly applied the law as it was articulated, one in the Commonwealth versus Carter decision of last year, and then also using the Levesque case from 2002, which is pretty consistent with what his decision was. So it seems it's consistent with what the law is, and again, it comes down to he was also the fact finder, so he found certain things credible, and within that purview, when he looked at the facts that he believed to be, he applied it appropriately to the law.
So I guess I'm confused. Many others, I'm sure, feel the same way. How does someone get charged with involuntary manslaughter by assisting in a suicide, which is not a crime?
Well, I think what the courts have stated is there was at least according to the decision on the Carter case, there's some indication of the naivete of the young man, as well as his unstable mental condition, and taking all of that into consideration and having Ms. Carter know about all of that and then say the things she said, there is a likelihood that he would act upon that. So it's a little bit different than, I think, an adult at the end of life who's contemplated these things and is certain of their position in how they want to proceed in dying. But I think that when you look at the law and how it's been portrayed over the last 200 years, it's consistent with what factual findings he found.
Well, speaking of the law, let me quickly turn your hat 180 degrees and put you in the state rep seat for a second. After what you heard today, is there reason for the Commonwealth to have an assisted suicide law on the books?
No, I think this is very specific to this case. Again, you got to look at the comments and what was said. And this wasn't someone who was truly mentally stable to make a adult, thoughtful, deliberate decision, and was egged on. I mean, if you look at the Levesque case is a similar situation where it's an individual who has a long history of mental illness, was provided a weapon, was there to assist if need be. Those are pretty extraordinary cases as opposed to individuals who are towards the end of death and thoughtful and knowing what's going to happen. I just think we don't really need to do anything.
All right. Well, I hear what you're saying, but what about Michelle Carter's psychological stability? That's certainly challenging in and of itself, but apparently the judge didn't see it.
Yeah, well, I mean, again, we're not in the courtroom every day, and that's one of the things that's difficult to make a comment on is judges instruct jurors every day to pay attention to not just what witnesses say, but how they say it, and they are the sole judges of the facts in making a determination of a case, because they have the ability to watch someone say something. We do that every day in our own common everyday experience. When I don't get to see how someone testifies and what happens, I can't make that determination unless I'm there and watching, and a judge who's got a lot of experience watching those things made that determination and was clearly thoughtful in making his specific findings.
Well, if you are the defense, are you planning some type of an appeal?
Oh, obviously. I mean, I think this is a case that is really kind of goes towards what law school is about, and it's a law school case where there's so many factors to it. And it's a difficult case for the Commonwealth, and it was a difficult case for the defense. Emotionally, it was, a horrible case. On a legal case, it's close. It was a close call. But when you look at the facts, again, that the judge found, and then you look at the law, seems that they met their burden. I don't think there's really much in regard to the final verdict that can be appealed, but there may be nuances of certain evidence that I didn't know didn't get in or did get in that shouldn't have gotten in. And again, I'm not familiar with all of those things because I didn't watch every day and I wasn't involved in it every day. So I'm sure they're going to be looking for what evidence was excluded that they wanted to get in that they felt was relevant and could have swayed the judge, and or what evidence came in that prejudiced Ms. Carter.
Well, I think there is a long list of things that the defense has to go through. Let me ask you, the bail was not revoked. Is there a chance that the judge could say, yes, you are guilty, but you're not going to do any time? What's the probability of something like that?
That I don't know. I mean, it's good to see that the judge is doing a pre-sentence report to find out information on that, I think.
And what does that mean, please?
That is an opportunity for the probation department to interview the defendant, interview other people around the defendant, as well as the victim's family, to make a determination and to give some more background to the judge as to who this person is, and then try to accommodate a sentence that, basically accomplishes the three things that a good sentence would do. One is make it a sentence that is rehabilitative, one, a deterrence, two, and then basically what I call is a restitution type sentence where there would be some type of payback for the victim. And I don't mean it in a monetarily way, but of trying to do what's right with all three of those things. And again, when you look at it, I think the judge is going to spend time on it. Clearly, it's a high-profile case, so they'll have a thoughtful pre-sentence report from a probation officer. And I'm sure it will be something that the judge relies upon when he makes that determination after he gets a better picture of an individual. I think it makes sense. I mean, I look at it as, when you go to a doctor, the doctor wants you to know your history before he diagnoses you with anything, or what he decides what is your best course of action in relation to the treatment of whatever illness you have. That's what a judge should be doing now, and he's doing that to hopefully make a sentence that can accomplish all those goals.
So, obviously you don't know what it's going to be, but I'm finding it hard to believe that she won't get any time, and on the other side, very difficult to believe that we're looking at 10, 15, 20 years.
Honestly, it's so hard. This is one of those things that it's unique, so I couldn't tell you. And again, I don't know the nuances of. I can see her getting probation, and I can see her getting 10 years.
Interesting.
To me, I really don't know, because it's just I don't know the nuances to her illness, exactly what it is, if there's a legitimate illness, or how, more of the circumstances of why she did what she did, and that may be explained in the pre-sentence report. I don't know. But there's a whole variety of things that I think the judge could do, and from one end of the spectrum to the other, it wouldn't be surprising.
I got you. Now let's talk about the judge. You've argued in front of him. You've gone against him when he was an attorney. I don't know how he feels about the limelight. He certainly got it with this particular case. How surprised would you be if in 30, 60, 90 days he announces his retirement? Because I don't know how you get another high, so to speak, like this trial has given him.
Funny, he made. I for some reason, and I don't mean to be disrespectful to Judge Lonas, but hold on, let me just see if I can figure that out. He may be
at that age.
Yeah, he may be right at that age right now. So that wouldn't surprise me. But he is a very competent, capable lawyer who, and a very capable, competent judge who I think, quite frankly, when he became a juvenile judge, I was surprised because I thought maybe he would become a superior court judge. I thought he's a class act, smart, firm and fair and thoughtful, compassionate. He's a very, very, very good judge. We're lucky to have him as a judge. He was a great lawyer too, very smart, a fighter for his clients, and it was always one of those lawyers you had to be very prepared for. And as a judge, he's the same. He expects a lot out of you. He's not rude to you. He's polite. He's all of that, but he expects a lot out of you.
Well, you and Attorney Santos, all of the attorneys that I've spoken to, have high praise for this guy.
Yep,
and as much as I disagree with his finding, I have to agree with you that he spelled it all out.
Yeah,
Certainly from the side of the street that he was looking on, and he was in that courtroom from beginning to end. I certainly wasn't, but he spelled, he did the alphabet with this.
Yep. And if you look at the cases that he relied upon, particularly the Levesque case, you can see how you could get that. Now, I think the one, if there's going to be ever an issue, is the conversation of what I think a single justice in the case called a virtual presence by the communication. I think that may be an issue. In the end, I don't know, but the fact that someone is not present at a scene, does that make a difference? And that would be interesting, although the SJC, in their decision that they decided on this case back last year, I think it was last year, yeah, right around this time, they seem to be saying that they didn't really have that much effect, but now that it's a guilty finding, we'll see.
Well, I'm going to let you go with this last question, and I think it's a pretty big one. One of the things that Attorney Cataldo was saying is that the text messages were protected free speech. It turns out in this particular case they aren't. What about any First Amendment right here? Well,
isn't there that old saying, you can say anything you want except fire in a crowded movie theater? And that's something to that effect?
I've heard it, yes.
If you create a danger to that effect, then it's really not protected speech. You create such that danger. Disorderly person and disturbing the peace, you have a right to say certain things and do certain things, but if it's going to disturb the peace of the community, it becomes a crime. And that's been litigated before, and it's been upheld that there is certain limitations on free speech.
All right. Well, thank you very much. I really appreciate it, State Rep.
Yep, you got it.
Chris Markey joining us, an attorney who's argued in front of Judge Moniz several times. And, man, what do you have to say about guilty? She was found guilty. Michelle Carter, guilty, still out on bail.